So what happens if you're partially at fault in a car crash? Does that mean you won't get financial justice? Not here in Louisiana. In this video, I'll explain how Louisiana's comparative fault law works, how insurance companies determine fault, and what you should do if you find yourself in a situation where you're partially responsible for the collision. Hey, I'm attorney Lloyd Bourgeois, your Louisiana injury attorney. I've spent years helping injured people just like you fight back when insurance companies try to take advantage of them. If you've been injured in a crash and need someone in your corner, give me and my team a call at 504-882-9867 for a free consultation. So let's dive into the specifics so you know exactly what steps to take if you're partially responsible for a crash. So Louisiana operates under a comparative fault system, which essentially means that fault for a crash or any accident is divided based upon each party's level of responsibility. So if there's 2 parties, each party's going to get a level of responsibility. If there's 5, each party may get a level of responsibility. The amount of compensation or financial justice you're eligible for is going to be determined based on the percentage of fault assigned to you. This is a crucial point to understand because it directly affects how much you ultimately receive. For example, if you're involved in a crash and the jury finds you 20% at fault and the other driver 80% at fault, you're able to recover 80% of your damages from the other party. In Louisiana, currently, we are a pure comparative fault state. This means there's no cutoff for how much fault you can share and still recover damages. Even if you're 95% responsible or 99% responsible, you can recover that 5% or 1% of your damages. Though the recovery in those situations is probably going to be pretty minimal, it may not always be. However, under new legislation, if you're found to be more than 50% responsible, you may lose your right to recover any damages altogether. Either way, this gives a fair amount of leeway to folks like you who may be partially at fault for a crash, but it also means you need to be proactive in proving your case to avoid a larger share of the fault being placed on you. Now, you may be wondering, how do they decide how much fault is mine? That's where the process of determining fault becomes essential, and it can be contested. Several factors come into play when assigning fault, such as police report, witness statements, physical evidence from the scene, traffic laws, and other information that may be relevant to your specific case. If the other party claims that you are responsible, but you disagree, there's room to challenge that both in negotiations and in court. For example, let's say you were in a car crash while merging onto a highway, but the other driver was speeding and rear-ended you. Now you may be partially responsible for not using your turn signal or merging over too quickly, but the other driver's speed could be the primary cause of that crash. It's essential to have strong evidence on your side, such as dash cam footage, witness statements, or police reports that can show the other driver's actions were a more significant factor in the crash. In these situations, working with a personal injury lawyer becomes invaluable. Lawyers can help gather evidence, challenge wrongful fault assessments, help establish the credibility of the parties involved, and ensure that the other party's liability is accurately portrayed in the case. Having legal representation also prevents insurance companies from unfairly reducing your settlement or denying your claim by giving you an outsized portion of fault when that is. If you were partially at fault in a car crash, it doesn't automatically mean you can't file a claim. You can still seek compensation, but as we've discussed, your recovery will be affected by your percentage of fault. The challenge here is to not admit too much responsibility when speaking to law enforcement. You should be cautious about admitting fault or saying things like, "I didn't see that car," or "it was my fault for speeding." Even if you feel you may be partially responsible, these statements could be used against you. Let's say you were in a rear-end collision, and the other driver is claiming you didn't brake in time. You may have been distracted, but you were not the one who caused the collision. It's critical that you gather evidence such as traffic camera footage, witness testimony, and photographs from the scene to show that while you may have been distracted, the other driver's tailgating or failure to brake in time was the main cause of the crash. In these cases and others, it's important to have a lawyer who will fight to show that the other driver's negligence played a more significant role, even if you share some responsibility. A good lawyer can also help negotiate a fair settlement with the insurance company that takes into account your percentage of fault, while also ensuring you don't receive a lower payout than you're entitled to. Navigating a car crash claim can be a complex process, especially when you're partially at fault. But in Louisiana, you still have options to recover damages. However, it's vital to carefully assess your case, gather evidence, and if necessary, challenge default assessments to ensure that your compensation is fair. If you've been in a car crash and you're worried about being partially at fault, you don't have to face this alone. Consult with a personal injury lawyer who can help you navigate the complexities of Louisiana's comparative fault system and fight for the compensation you deserve. If you or someone you care about has been injured in a crash and you're looking for an experienced attorney who will fight to get you the financial justice you deserve, reach out to me and my team today at 504-882-9867. And if you found this video helpful, hit that subscribe button and check out this next video.